Hello, I'm Todd Smith, and this is your Appellate Tip of the Week. This week's tip is prepare proposed trial court orders with an appeal in mind. So if you've gone into a hearing and you've actually won the hearing, or if you anticipate winning and you're preparing a proposed order in advance, you want to be careful not to overreach. In other words, you may feel really good about your position, that you've beaten the other side and you're going to nail them to the wall. But what you need to do, what I recommend, is think about what that's going to look like if the order is going to be reviewed by an appellate court. You could wind up, if you build in too many things that you're not really entitled to, you could wind up creating an appellate issue that didn't exist before. And you could wind up motivating the other side to take an appeal that maybe they wouldn't have taken. So there's really no shame in this situation in negotiating the form of an order, even if it means you have to give on something that it's debatable whether you're entitled to or not. The trial courts, I know, appreciate when parties come into court and have essentially agreed on a form, and there's been some give and take in the resolution of what the form of order is going to look like. Now, don't get me wrong. If you are entitled to something, you shouldn't negotiate the substance of the order. Go with what the court is allowing you to get in terms of relief. But it doesn't generally pay to stick to your guns on something that's really not worth fighting about. If you have some points that you can give, maybe you can horse trade with your opposing counsel a little bit, and there can be some give and take in the form of the order, because resisting that temptation to overreach can often help you get to resolution faster, maybe even avoid an appeal, and certainly avoid having a more complex appeal than there needs to be. That's it for this week's tip. We'll see you next time.